A very good evening to you all, and welcome to Ask the Property Experts with me, Kura Chiota. We're tackling more of your questions tonight, especially those with a legal focus. And do remember, you can join in the action live in our studio. Give us a call on 011 280 3899. Who better to answer our legal questions than some lawyers? Joining us from Ramsey Webber Attorneys, Melissa van der Vaart, and for the first time, Pienaar of Schindlers Attorneys. Thanks for being with me tonight.
Thanks, Kura.
And with being all of us here tonight. My first question is, when we receive questions somewhere at the point of pain, Tommy from Pretoria says, "Help, I have a big problem. I own a property in Pretoria and there's a tenant staying at the property. I stay in Bloemfontein and the tenant is responsible for all electricity and water payments. But it's come to my attention that they are in arrears 35,000 Rand. I want to know, how is it possible for the account to be in such arrears without the city of Tshwane cutting off the supply? In the past, when we had an account and we did arrears by 600 Rand, they would disconnect us. It seems to me that the tenant has made arrangements with the municipality to pay off their account accordingly, but in the end, they do not even pay a single cent. What information can you help me with along this regard? Help me out."
Well, Kura, I think to begin with, it's not a simple answer. At the end of the day, and until recently, the council would insist on all municipal accounts being in the registered owner's name. Many years ago, the council was happy for those accounts to be in the tenant's name as long as they were serviced correctly. The situation you have now is that the council are insisting that the accounts be in the registered owner's name, and to that extent, the registered owner is ultimately the person responsible for servicing those accounts and making sure that they're paid. And I can't really comment on what happened in this particular scenario, but I can only assume that the registered owner did not check up and follow up on the accounts and make sure that they were being serviced by the tenant. The council is, of course, at liberty to terminate the services if they aren't paid for. What cannot happen, though, is that a registered owner who has a valid and binding lease with the tenant, he cannot unilaterally terminate the services or insist that the council terminates the services for so long as there is a lease in place. He would have to first legally terminate the lease in order to terminate those services.
Okay. Melissa, not a comfortable spot to be in. How can our landowner, Tommy here, get his money back? Does he take action against the tenant while settling off with the council?
I'm a little bit uncomfortable to look at 35,000 Rand outstanding with the council, and the first question that comes to my mind is it actually a correct bill? We see here in the news regularly at the moment, there's incorrect accounts coming out of the council, and is 35,000 actually owed by the tenant, or in this case by the owner, but the tenants, in terms of the lease agreement, it seems responsible for that account. If there is any sum of money outstanding and there is an agreement between the tenant and the owner that the tenant needs to pay for the water and electricity, the owner can of course take steps, institute a civil claim against its tenant for the repayment of that rates and taxes or electricity or whatever it may be that the tenant's responsible for.
So all is not lost. Yeah. Tommy, take some good advice on that. The second question coming through, and in this day and age where finance is hard to come by and people who've got bonds want to extend them, perhaps easier than taking a new bond, I have an unsigned question here that says, "I just wanted to find out. I made a further loan on my property with one of the banks and I was charged an additional amount, additional charges, for future legal costs. Is this legal to be charged for future legal costs in case the bank incurs legal costs against me before they incur those costs?" Melissa, you sign tons of these a day. What's the story here?
I'm a little bit alarmed that this person is only coming to acknowledge that this is something on his documents at this stage, because it's a further bond, and it's certainly something that would be on every bond. The four major banks that provide lending, this is something that will be in their bond documents.
So it's a standard term. As much as I hate the word standard term,
yeah.
If it's a bad term, I don't like it. I'm going to try and negotiate my way around it, but it's a standard term. And when I sign bond documents, the agent usually gives me a nice little piece of paper saying, "I have read and understood the terms and conditions on the contract that I'm about to sign, and I merely sign it." Are you saying that there's a way around? Is there a gap between the two here?
No, I think I think it's there in every set of bond documents. Most sets of bond documents are sort of 71 pages. And unfortunately, people get tired. They've been sitting there for an hour, and they want to sign. They want to get out of there. They want to go home and do their things. And probably this was explained to the client in the first time, but now only taking cognizance of this clause. And the clause basically deals with the fact that the bank is saying, right, Mr. person who's taking a bond with us, you want finance, but there is a risk that you maybe cannot pay your bond. There is a risk of you defaulting in the future. I'm not saying you're going to default, but there is a possibility that you may default. In the event of you defaulting, we're going to incur costs. We're going to have sheriff costs, we're going to have legal costs, we're going to have expenses that we as a bank are going to have to outlay initially. And we need to ask you to pay for it because you're the person who's defaulting. You're the reason we're incurring those costs. If the client takes a bond of 300,000 Rand, they are responsible for that bond, but by the time they default, they owe 300,000 Rand and sometimes a little bit more than 300,000 Rand because of the interest. So how does the bank claim back the expenses of the legal? And that's where this additional sum comes in. Sorry, the additional sum is making provision for future legal expenses if they are there.
So it has no implications. It's not a drawdown on a loan. You're not going to start paying interest on it. No. It's in the eventuality you default and there's legal against you. They've got some extra cover there.
Never default. It never ever comes into effect. It's not something that you're liable for at all. You pay on your 300,000. You pay your interest on that money, and that's that. You walk away from the bank after 20 years and you say, right, Mr. Bank, I've settled my bond. I'm done. Most banks look at a percentage on this, so it varies anything. Some of the banks are charging 10% as an additional, or making provision for 10% as an additional sum. Some of the banks go up to 25%. As I say, much as we don't like the word standard, it is a fairly standard thing in mortgage bonds.
Got you. We have a caller coming through from Sandton. Is it Cindy or Sandy? Please go through. You're through to our studio.
Hi, Kira.
Hi.
I have a question about the pick it up strike that's happening at the moment.
Okay.
Two parts. Firstly, our bins haven't been cleared for weeks, and we're still paying rates, and the workers aren't being paid, and
Correct.
The rubbish isn't being collected. But pick it up are still getting, and the municipality are still getting the money from us. Why should they get full income if we have to suffer? That's the first question. And secondly, if Pick It Up is a registered company, even though City of Joburg is a sole shareholder, surely under the new CPA Act, this is grounds for class action.
I love it. A CPA question, pick it up and topical. I want to toss that one over to you, Andre.
Okay, well, I'll deal with the CPO question just now. Firstly, in terms of the rates accounts, any amounts that have currently been billed are obviously in respect of services that have previously been rendered. Those accounts are going to be payable. The service has been provided, and therefore the amount should be paid. In respect of going forward, and the charges that are going to be put through by the council, there are regulations dealing with municipal charges that are payable by homeowners, and unfortunately, as South Africans owning immovable property in this country, we just have to be mindful of the fact that we are liable for those charges, and that living in a democracy as we do, from time to time there are going to be strikes and there are going to be labour disruptions which are going to prevent those services from being rendered timelessly or at all. But that does not negate the fact that we have to pay for these services, and I'm pretty sure that Pick It Up at some stage will certainly climb back on board and pick up all the rubbish and clean our country up. So that's, I think, sufficiently answers
But
the
I
first
want a
question.
class action suit. I want some action. I want to get onto it.
Well, in terms of the Constitution, you're certainly entitled to bring a class action suit if you have the necessary cause of action. In terms of the CPA question, it's a difficult one. CPA provides for protection for a consumer in circumstances where services are being provided in the ordinary course of business. This is obviously a situation where one also needs to be mindful of the fact that there are certain exemptions in the CPA, and the state falls beyond the applicability of the Act. So in terms of whether the CPA would apply to Pick It Up, if it's a private entity and it falls beyond the thresholds, and there are certain limitations in terms of juristic entities, turnover, asset value, but if if the Act is applicable, and I haven't really applied myself to whether it would be applicable to this particular organisation, but it is an organ of state, as far as I understand, and I don't think the Act would be applicable in the circumstances.
Okay. Melissa, he's disappointing me. I want to go after them. Can we?
I think the biggest thing is, as far as I've read, is certain municipalities have been exempt by the...
Yes, the high capacity municipalities, and I hope Johannesburg certainly is one of those.
And there's been a call to have that notice overturned or removed or withdrawn, however you want to put it. I don't know if there would be room in the CPA to take action, but certainly there might be room in terms of other legislation to take action. They mean to be providing a service, they're not able to provide the service, or they're not providing the service at this stage. And it might be something to explore from a litigation point of view. Not my forte, but certainly something worth looking at.
Disappointingly, we can't do anything about it. I'd love to see a David versus Goliath taking on the city. I have a question here from Elias Makubo. He says, I have a friend who put in an offer to buy a plot and the bank declined due to affordability issues. There was a suggestion that and with legal advice, a deposit of 300,000 was paid, which is half, and they wanting to pay off the future. They want to pay the future amount off. The amount off into the future. So it's becoming an installment sale or a deed of sale. What are the differences between those, and what would we advise Elias, who's worried about their friend doing this? What advice can we give him?
Elias has cause for concern. It's not a simple transaction. Elias doesn't specify whether the property is agricultural or residential. Notwithstanding, I believe it would fall into two possible different scenarios. One is a lease incorporating an option to purchase, and the other is the purchase of immovable property by way of installments as contemplated in the Alienation of Land Act. Now, I would suggest that it falls into the latter category simply by virtue of what Elias has stated. But having said that, one also needs to be aware of the fact that the Alienation of Land Act has very mandatory prescriptions as regards to the disposition of immovable property. Chapter 2 of the Act sets out mandatory requirements which have to be present in order for immovable property to be disposed of. For example, it must be in writing. The details of the property need to be clearly set out. The parties need to be described, etc., etc. Sections 4 to 25 of the Alienation of Land Act go further, and they describe situations where immovable property is sold by way of installments. And there are certain mandatory prescriptive provisions that need to be complied with there as well. So, for example, the purchase price of the property needs to be agreed upon. The number of installments need to be agreed upon. When registration will take place needs to be agreed upon. Now, that's quite interesting because in terms of the Act, there is a maximum period of 5 years in which to transfer or register transfer of that property into the I'm going to use the word tenant's name because it's a person starts off as a tenant. In that situation, where you've got a credit, it's a credit agreement, effectively, as contemplated in terms of the National Credit Act, where you have a credit agreement of that nature, which starts off as a lease and becomes a sale of immovable property, the rentals will go towards reducing the purchase consideration, and interest will obviously be applicable. But if registration doesn't take place within a defined period as agreed between the parties, then interest can't be charged on the amount from the date of that default. So it's an interesting situation. The benefit to most parties entering into transactions of that nature would be that they don't have to approach a financial institution because there's usually affordability issues. They can enter into a private treaty with a seller who charges a much lower rate of interest, and obviously the property can be transferred to them within that 5-year period. And although the installments are going to be higher than they would be at the bank, there is still protection for the purchaser in those circumstances. However, I just want to mention that I think the 300,000 Rand deposit that was paid should have been paid into an attorney's trust account.
Or an agent's trust account.
Or an agent's trust account.
I'm going to have to take it there. We're going to take a quick break. Don't go anywhere. We're going to be right back with you soon.